Okay, we are here this morning on matter CV2024-036727, the matter of Brett and Shauna Woolley and Seth and Maria Arthur versus Greenfield Lakes Owners Association. Can I have counsel announce?
Good morning, Your Honor. Michael Hernacek on behalf of the Woolleys and the Arthurs.
Good morning, Your Honor. Kyle Von Johnson and Dion Franklin on behalf of the Defendant Association.
Okay. And we are here for oral argument on the defendant's motion for summary judgment and the cross motion for summary judgment. Greenfield, are you ready to proceed?
Yes, Your Honor.
Okay.
I think most of my argument is going to be at the Elmo.
Okay.
With the court's leave, I just have free reign over the desk and the Elmo throughout.
Get that turned on for you.
While we're getting that on, Your Honor, this is a case of a dispute between an HOA and homeowners. The main issue in the case is who's going to maintain walls that exist between common areas and the private lots that are owned by the homeowners.
Can you check and see if that's on?
Yeah.
Never mind. Okay, go ahead.
Perfect.
Just takes a second.
To start out, Your Honor, I just want to give you some context of this area of the neighborhood. And to do that, I'm going to show you the plat, which is one of our exhibits in the statement of facts. So the two properties at issue, zoom out a little bit. That's it. The two properties at issue I have marked, these are not marked in the exhibits, as Lot 87 and Lot 59. This is the Woolley lot and this is the Arthur lot. The dispute in this case is over the walls bordering their lots and then the association's common area. And it's important for the court to recognize for the Woolley lot, this Woolley property exists on a canal. It borders a canal. And there is a wall that runs the length of the neighborhood on that canal. So it separates the properties from the canal. There's a little bit of common area, a tiny piece of common area designated as Tract D. You can see right there. And that's the dispute here is the association required to maintain 100% of that wall because it's next to common area? Or is the association obligated to split that cost? Do the lot owners pay 50%? Does the association pay 50%? So that's the wall at issue with the Woolley property. The Arthur property is down here, Lot 59. And the Arthur property borders common area on two sides. So we've got Tract C and we've got Tract B. And so there's two walls there that border the common area and the lots. That kind of sets the stage for the dispute from a 10,000-foot perspective. As part of this lawsuit, the association obtained a survey to see exactly where those walls are located. And I'm going to pull the survey up first. First, we're going to look at the Woolley wall. And again, we want to emphasize the fact that this wall does not just span across the Woolley property, it spans across a number of properties. It's one wall going down the canal. And it's important for the court to understand that this wall, like every other wall in the state, the builders didn't build it exactly in one line. It teeters outside and inside the property line as the wall extends. And I think that's been a point of serious confusion in this summary judgment dispute is where this wall is actually located. And I just want to show you here in the survey, the surveyor saying the wall is 8 inches wide. So the wall itself has a depth to it. And I brought a tape measure to just illustrate. So 8 inches. The wall is this wide. And what the surveyors did was they went along the wall periodically and said, okay, where is the wall in relation to the property line? and they measured it from the outside face of the wall. So there's two sides to a wall. The outside face is the face that faces the common area, and the inside face is the face that faces the lots. That's how the surveyor referenced the wall. And then we can see throughout this survey, so it starts to the property next to the Woolley property. It says that the outside face of the wall is 0.8 feet outside of the property line. So what the surveyor is saying for that specific measurement is 0.8 feet is roughly 9.5 inches. So we go to 9.5 inches. What the surveyor is saying is the wall is located entirely outside of the lot by about 1.5 inches. That makes sense, Your Honor?
Except for the word entirely.
So we've got 8 inches of wall, and the outside face, they're saying, is 0.8 feet away from the property line. 0.8 feet is, we use the American system, not the metric system, so there's 12 inches to a foot. So 0.8 feet is roughly 9.5 inches. So the property line is 9.5 inches behind the outside face of the wall.
Right.
So if you're looking at the wall, 8 inches of wall and then property line, the wall is entirely on common area at that point by about 1.5 inches. And that sets our measurement so that we can see across the row that was surveyed. We see it goes 0.8, then it goes 1.2, 1.0, 1.4, 1.5. All of these are on common area, and we acknowledge that. What ends up happening, though, is as you go down the line, again, this is an entire canal. It's one long wall. You go down the line, the surveyor, because of space, split lot 88. So lot 88 continues down here. So this is one continuous wall. It's split in half. You get to lot 88 and you see, okay, 1.4, 1.0, 1.1, and then it goes to 0.6. So now we're seeing 0.6 of a foot is roughly 7.5 inches. So now we're seeing an 8-inch wall. That's the outside face is 0.6 feet away from the property line. That means the property line is under the wall at that point. Now we're seeing the wall creep into the lot. And we see it goes even further. We go 0.6, 0.3, 0.2, 0.2, and then we see the outside face of the line is with the property line. So now we've got 8 inches of wall, and the outside face of the wall is on the property line, which means the entire 8 inches of wall is on the lot at that point. None of it is on the association's common area. And I think that's been a major point of confusion in this case is plaintiffs are saying that this is a common area wall because it's located entirely within common area. And it just simply isn't based on the survey. And I'd like to briefly look at the Arthur wall, the other property. It's lot 59. We can see the surveyor again indicated the same 8-inch wall. And we can see on this corner, it's 1.1 feet outside of the wall. So we acknowledge it's on common area entirely, just barely, but entirely on common area. But even on the Arthur lot, if you look at the other corner of his lot, it's 0.1 feet outside of the property line, which means out of the 8 inches of this wall, 0.1 feet is on the association's side of the property line, or roughly 1.2 inches. The wall is mostly on Arthur's lot by that point. So it just crosses over the property line at his lot. And then if you continue the wall across the other properties against his neighbors, again, it's still 0.1, 0.1, 0.3. That wall is mostly on the lots. And that's a critical issue in this case, Your Honor, because plaintiffs are saying that the association is responsible for maintaining the association's common areas, and we acknowledge that the association maintains the association's common areas. The issue here is that this is not an association-only issue. This is a shared wall that they're sharing with the lot owners. And the association wants the lot owners to take responsibility for their half of the maintenance costs. I want to bring the court's attention to a few areas in the CC&Rs that are applicable to this dispute. Real briefly, 3.1 just sets the standard that owners have easement rights over the common areas. That's a general easy proposition. Owners can use the common areas in the association. Same with 6.3. We have the same type of language here. Each owner has a non-exclusive right to use the common areas. So we can see owners use common areas. Well, what happens when the association needs to step in and do some maintenance on these shared walls? Well, 6.5 sets an easement in favor of both the association and the owners for maintenance over these walls. So it's clear in the documents that both the owners and the association have some sort of easement rights and maintenance obligation over these shared walls. Now, the next section I want the court to take a look at is 10.1. And that's a big issue in this dispute because the CC&Rs address party walls to some extent. So 10.1 says that the owners and the association have rights regarding these party walls and that they're going to be governed by the general rules regarding party walls. Meaning, if somebody is negligent, they're going to pay for their negligence. If it's just general maintenance, you're going to split the maintenance obligations. And plaintiffs in this case take issue with this section specifically because it references walls between two lots and walls between parcels and lots. It doesn't say walls between common areas and lots. And that is arguably an oversight by the drafters. But the intention is clear here because the only time the association would have a stake in that dispute is if it's between common areas and lots. And the CC&R specifically identify that the association has these party wall rights. So if it was intended to just be private owners, there would be no reference to association regarding these party wall rights.
Where do the CC&Rs expressly state that the HOA has common or has party wall rights other than in the easement?
Right here. So we have party walls is section 10.
Right.
And 10.1 is saying the rights and duties of the owners and the association. So the CC&R is saying the association does have rights regarding these party walls, and the party walls are going to be treated like common law party walls. So the analysis here is either this section applies, you can say the intent of this section was for it to apply to the walls between common areas and lots as well, or it doesn't apply at all, in which case the general principles of common law apply because there's no other section on point regarding shared walls. Either way, the general principles of common law regarding perimeter walls apply, either through this section or through general common law.
Okay. Does the association property fall within the definition of lot in the CC&Rs?
No, Your Honor. The association's property falls within the definition of common area.
Okay, and it doesn't fall under the definition of parcel either.
Correct.
Okay.
Yep. Next, Your Honor, I'd just like to point out section 11 of the CC&Rs. This sets the general maintenance obligations. So 11.1 says that the owners are required to maintain their lots. 11.2, just below that, says that the association is required to maintain the common areas. So both parties here, to the extent that the wall is a shared wall between the lot and the common area, both parties have a maintenance obligation regarding how their respective property is served by that wall. Finally, Your Honor, for purposes of the dispute regarding the Arthur wall, so to give you some context behind that dispute, The Arthur wall at one point fell down, and the association was in the process of investigating the source of that because negligent acts require people to pay for their negligence, and they were trying to determine who had the responsibility to pay for the cost of that wall. In the interim, Mr. Arthur rebuilt the wall, and in that process, he converted the wall. It was a view fence. It was see-through metal. He converted part of that wall into just a block wall, and that changed the character of that wall. It changed the aesthetic of that wall. Everyone else on that line is a view fence. And under 12.2 of the CC&Rs, he was required to apply to the association and get approval to change the exterior appearance of his lot. And now in this dispute, he's attempting to seek reimbursement for the costs to repair his wall. But he didn't get the application, he didn't get the approval. His wall's not compliant, and the association's position is that that was a material breach of his obligations, and that the association is not going to be responsible for paying even half the cost of a wall that's non-compliant with the CC&Rs. If he wants the association to pay for half the wall, he needs to tear it down and rebuild a compliant wall, one that complies with all of the other aesthetic requirements in the community. Finally, Your Honor, I want to bring your attention to an argument that can be kind of confusing on paper. It's the 1033-04 argument, and I've just got a handy statute book that I reference. Let's see if I can just zoom that out. So this is 1033-04. This is in the nonprofit corporation statutes. And what this statute says is, except as provided in subsection B, the validity of a corporate act is not going to be challenged on the grounds that the corporation lacked the power to act. So B is our operative section here, and it splits out situations between nonprofit corporations that are HOAs and nonprofit corporations that are not HOAs. So B1 talks about the non-HOA challenges, and it says you have to have 10% or 50 members to bring a challenge to that nonprofit's authority to act. The legislature in B2 identified situations where, hey, in an HOA dispute, in a proceeding by any member of a condo or a planned community, that's our HOAs, in a proceeding against an HOA, any member, so you don't need the 10%, you don't need the 50 member requirement that you would under B1, any member can challenge the corporation and enjoin the act. That distinction is important because under subsection C, the legislature is saying, if you bring a challenge under B1, not only can you get the injunction, but you may get awarded damages for loss. So the legislature is saying, you have a higher burden, you have a 10%, 50 membership burden to bring a challenge. If you succeed on that challenge, you can also get damages. In B2, they're allowing any member, just one person alone can challenge the association, but they're limited to injunctive relief. Come to the court ahead of time and get a decision before you have damages, if you're going to challenge what the association is doing. Now, the next question is, okay, it says challenges to the association's authority or power to act. What does that mean? Because that sounds like ultra-virus. Two statutes prior, so 1033-02, they give us examples. 1033-02 is general powers of nonprofit corporations. In subsection 4 of that statute, they say nonprofit corporations can, let's see if we can get that in focus. There we go. Subsection 4 of that statute says nonprofit corporations can purchase, receive, lease, or otherwise acquire and hold, improve, or use, and otherwise deal with real or personal property. And what we're dealing with here is the association's improvement and use of real property, the walls at issue in this dispute. There's also a catch-all in subsection 20 of that same statute, where the association has the power to do any other act not inconsistent with the law and in furtherance of their activities and affairs of a corporation. That's a really broad catch-all, but what are the activities and affairs of a corporation? It's the things they're doing under the CC&Rs. That's what differentiates an HOA under the subsection B2 and a dispute with any other nonprofit corporation. The HOAs have CC&Rs associated with their activities. So a challenge to the association CC&Rs still applies under this statute if a member is challenging the association's actions and saying it's a violation of the CC&Rs, they're still challenging the association's authority to do or not do whatever the homeowner is complaining about. And the legislature is clear that the challenge comes through an injunction. In other words, specific to Mr. Arthur, if he thought the association was obligated to repair his wall, he should have sought an injunction ahead of time so we could have that dispute over the obligations to maintain and repair, rather than do it himself and then try to seek damages after. He's not allowed to seek damages after. He missed his opportunity by rebuilding the wall himself, and then he built it non-compliant to the association's CC&Rs. So to recap, Your Honor, either the walls are party walls under the CC&Rs, or they're not, in which case they're party walls under common law. Either way, the parties have a shared maintenance obligation regarding these walls. And to the extent that Mr. Arthur seeks monetary damages associated with him rebuilding his wall, either he did it in violation of the CC&Rs and the association's not obligated to reimburse him the 50% that the association would have been responsible for, or he's limited to injunctive relief anyway, and he missed his opportunity to seek an injunction because he went ahead and rebuilt the wall and cleared the issue. And with that, I'm going to reserve the rest of my time.
Thank you, Your Honor. I'm going to speak from here unless you need something put on the elmo.
If you're more comfortable seated, that's fine as well.
Thank you. I'll stand and try to show the proper respect here. Your Honor, I think the one takeaway from counsel's argument that we can focus on is the point that you raised earlier. There just simply is no basis for finding that the HOA was an owner. There's no basis for finding that the HOA had a right to a lot. This was a parcel that, as we explained in our brief, was converted into common area when the plat was submitted to the county. That is the public document that is the Bible, if you will, as to what is going to take place in the community. That plat refers to the common area as the common area. And as we cited throughout our brief, the HOA under the CC&Rs has the obligation to maintain all of its common areas. And we went through the landscaping and the landscaping pertinence and the associated areas that are all under common area designation. And those common areas include the 10,000 linear feet of wall. I don't have 785 homeowners on this lawsuit, but I do have two. And the two that are before this court have had specific issues with the HOA shirking its responsibilities to maintain and own the common area walls. We call them common area walls. You can look in the public documents. You can look in the plat. They're referred to as perimeter walls. Regardless, they're outside of the lots in 99% of the cases. 90%, 99% plus of the Greenfield Lakes community have walls that are outside of the individual lot owners' lots. That's the end of the inquiry. Your Honor doesn't have to get excited about something that might possibly be characterized as a party wall. Why? Because the HOA can't be an owner of a party wall. It's simply not in the CC&Rs. So I'm happy to answer questions if you'd like, but I was just going to go through and walk you through the CC&R provisions that we cited, and it'll refresh your memory a bit, but we'll start with Section 1.4. These are the areas of association responsibility, and the CC&Rs say collectively This means the common areas and all land and improvements thereon located within the boundaries of a lot or parcel which the association is obligated to maintain, repair, and replace. Section 1.12 defines common area as including all tracts designated as common area on any plat, all land which the association at any time owns, all improvements located on each of the foregoing areas. Section 1.25 defines improvement means any building, fence, wall, fixture. So we're already there. We're already in those three sections at the point where the common area, which is owned and maintained by the HOA, is exclusively the responsibility of the HOA for maintenance. The walls are HOA walls. We call them common area walls, whether you call them perimeter walls, common area walls. One thing we do know, they're not party walls. They don't fall within the definition, and that was the basis of your question, I believe.
So what about those instances where the wall doesn't fall on HOA property?
Your Honor, that happens in less than 1% of cases, and it's a slight infringement. And if you look at the surveys, even...
wait a minute.
I'm sorry.
So even though it's not on common area property, the HOA has to pay for it?
Our position is that it's all on common area it's all on common area at some point. That if it weaves into a individual lot owner's lot line, that is a mistake on the building side. It's not a mistake on the plat. It's not a mistake on the law that applies to the plat. It's not a mistake on the CC&Rs.
Okay, so your position is even if it's on private property or the homeowner's property, the HOA is responsible for it.
I want to be specific in responding to your question. I believe what you're referring to is the extensive line of wall that runs for 10,000 feet around the perimeter of the Greenfield lakes. If some part of that wall encroaches on an individual lot owner's lot, then yes, it is still the HOA's maintenance responsibility exclusively. And we can justify that because, again, this is not falling under the definition of a party wall. It just isn't. Why? Because the HOA can't be an owner. The owner is the only one that could have a party wall. The council pointed out the maintenance obligations under easements. That doesn't justify designating the HOA as an owner, if that makes sense.
It does, yeah. Okay, you can proceed.
So I'll just continue on. Section 6.5 refers to wall easements, and this provides for necessary wall easements in favor of the association to fulfill their responsibilities and are adjacent to the perimeter boundaries of the project, a street, and or a common area for reasonable ingress, egress, installation, replacement, maintenance, and repair of a project perimeter wall located on the easement. Then I can bring up the final plat if that's helpful to you. Can you put it up? Do you mind if we share our screen on the final plat here? Yeah, so this is the final plat. This is what was recorded with the county, and then the one with the language on the side, the legend that we referred to. Okay. Well, we can quote from the language, but on the plat itself,
it's in the summary.
Right. It says all landscaping within tracts A, B, C, and D is to be maintained by the Greenfield Lakes Homeowners Association. We didn't come up with that language. The original developer did when he submitted the plat. That is binding.
Right, you're saying that walls fall within the definition of landscaping?
Oh, yeah.
Yes, Your Honor. That's well, it falls within the definition of improvements, which we discussed in section 1.25.
Right, and throughout your brief, you talk about landscaping requirements, but
it is also considered landscaping.
The wall is considered landscaping.
It is, Your Honor.
And where is that in the CC&Rs?
There's no definition for landscaping in CCRs, but you can search anywhere, and it's hardscaping and softscaping.
Okay.
Any definition you can find online would show that.
Right. So forgive me. The CC&Rs do not specifically define landscaping. They discuss hardscape and softscape, but they don't actually define landscaping. So we're going to skip over just slightly to the basic rules of construction when it comes to contract interpretation. And that's what Your Honor is doing. That's why we're here at summary judgment, because we don't need to have a fact finder in here to tell you that the decision you're making is based on the interpretation of contracts that each one of these lot owners have in force with the HOA. And each one of those lot owners, if they were to come in here and testify, would come in and say exactly what the plaintiffs have said, which is our understanding when we purchased this property was that the HOA would maintain the common area walls, and that is directly at issue. If I can take another sidestep and say that the argument about the Arthurs improperly attacking the HOA is not accurate. It's not a fair representation of the action that they took. There was months of communication, and we submitted that in our statement of facts. And I believe if Your Honor just takes a glance at it, you can see that the Arthurs didn't just write a few emails. They went out and solicited bids. They got cost pricing. They submitted it. They said, we need this taken care of. Our wall is falling down. It's not just the fence. It is also the monuments attaching the fence. We need this addressed. And the HOA did nothing for months. Months and months and months. And as Your Honor may note in our reply, we pointed out that this is not unusual. This is happening across the board, across the neighborhood of Greenfield Lakes. And there's another Maricopa County Superior Court case that was just resolved 2 years ago. And that case was an HOA initiated lawsuit against the homeowner for exactly the same argument, that there was some encroachment on the lot line and therefore it was a party wall. Therefore, the homeowner bore the responsibility for maintaining it and fixing this wall that had collapsed. And that was the Zipchak case. And I gave you the citation in the reply if you have any interest in taking a look at it. This case is just emblematic of what is going to continue to happen if we can't convince Your Honor to take deliberative action now and settle the contract dispute here. If there is any ambiguity in the CC&Rs, it's construed against the drafter, and that's the developer and in whose shoes the HOA now stands. I'll just go ahead and put this on the screen if I can share this from the Elmo. So here is the part of the plat dedication.
Oh, just a second, it's not on. There we go.
Okay, so as you can see here, tracks A, B, C, and D, as shown here on, shall be owned and maintained by the Greenfield Lakes Homeowners Association. And again, that language applies to the improvements thereon, and the improvements include walls, fences. Another document that we referred Your Honor to is the public report. I don't know if you saw that, but we attached that to our reply. We didn't mean to surprise anybody, but it is a public document and it does form the basis for what was submitted to the county as an announcement that this is the intention of the community. And that public report specifically, again, reiterates, this is August 1st, 1997 on page 6. The report says, subdivider to complete the equestrian trails and landscaping by June 30th, 1998, which will then be maintained by the Homeowners Association. Costs to purchasers for maintenance are included in the Homeowners Association fees. So going back to your earlier question, if there was part of the HOA common area wall that encroached on my lot, my understanding was still the same, that common area wall that's out there on common area primarily, even if it's encroaching on my lot line, the maintenance for that wall is going to be up to the HOA. And how do I know that? Because the public report and the CC&Rs designate the HOA as the responsible party for that. The architectural guidelines and community rules, this is another part of the founding documents that you can look at for the HOA's responsibility for maintenance. It says the association is responsible for a number of community functions, including maintaining the wash corridors, landscaping, certain perimeter walls, and signage. So again, without the definition of landscaping, if for some reason Your Honor was inclined to find that these were not encompassed within the common area definition we provided earlier, even the landscaping obligations fall on the shoulders of the HOA. So let me talk about party walls for a second, if I may, unless you have questions. If you're not on the fence, no pun intended.
No, you can proceed.
Okay. Section 10.1, as counsel pointed out, does talk about party walls, and it describes them as a wall or fence located between two lots, between two parcels, and or between a lot and a parcel. Okay, so as counsel pointed out, part of the Woolley's lot is along the canal, but there's 20 feet of common area between his lot and the canal. That common area is solely the responsibility of the HOA. No matter how thin that line was on the plat map, that is the HOA's responsibility, and that is throughout the neighborhood. That common area is not a foot or 2 feet or 3 feet wide, as you can see on our survey and on even the EVDS survey that the HOA submitted. We're talking about 20 feet. It may not be a uniform 20 feet, but that's all common area, and that all is within the HOA's responsibility. So how does that relate to party walls? Well, the HOA, once it was assuming the responsibility for the common area, those parcels ceased to become parcels, ceased to exist as parcels. And the CC&Rs use that word, cease. They ceased to become parcels. Then if you go down to the definition of owner, this is 1.37. Owner means the record owner to any lot or parcel. Section 1.28 states lot means each portion of the property separately designated and described as a lot on a plat. So again, that plat that we had up, we can put it back up again. This plat is the alpha and the omega. This plat is what defines common area and what defines lots. We don't have parcels anymore. The HOA cannot be an owner because they don't have a parcel. They didn't once the plat was recorded. I want to talk just for a second about the proposed amendment. We submitted this, and Your Honor, this was an action that was brought in part because of this proposed amendment to the community, and this has been the source of a great deal of strife in the community. Again, I'm going to put this on the Elmo if I may. This is the proposed amendment that the board of directors submitted to the community and ultimately later withdrew because of the uproar that was caused. Throughout this amendment, there are significant changes or proposed changes to the CC&Rs. And what are those changes? They're primarily targeting party walls. They're trying to redefine party walls. And again, one of the reasons that we're seeking injunctive relief is that even though this proposal was withdrawn, there have been recent publications by the HOA that they continue to press towards a party wall broadened definition that requires lot owners to take maintenance responsibilities for these common area walls.
What do you mean publications?
There have been blog posts and most recently, I didn't submit it, Your Honor.
Emails to the owners. So, there have been Zoom board meetings. They maintained what they tried in the proposal for Your Honor.
Okay.
But in other words, everything they tried to accomplish in that proposal, they just went ahead as if it had passed. They told all the homeowners that your project perimeter wall is a party wall, that they, the association, was an owner, and that a common area is a lot. And we have that one example in writing, if it's important for you to see it, where they actually said in a Q&A form that they emailed to all 785 homeowners that who owns the wall on a cul-de-sac? And they said, well, the HOA is the owner of the lot on both sides. So they still referred to common areas as lots, and they still referred to themselves as owners. even though they withdrew an amendment that tried to literally change the meaning of the words in the CC&Rs.
So I'd rather not go through the entire proposed amendment, but if you haven't taken a look at it, I would encourage you to glance at it to understand that this is not a sole and solitary issue affecting just the Arthurs and the Woolleys. This is an ongoing drive that is going to affect all 785 lot owners in Greenfield Lakes. And even those who are, I believe it's 350 plus that are on.
But somewhere between 300 and 350 have these perimeter walls.
It's not just those individuals that are affected, but of course the prospective buyers of any of those lots are going to be impacted, because this means that if these are no longer common area walls or project perimeter walls, then there's going to be insurance obligations and liability obligations that are going to significantly impact property values of any of these that are purchased. And then the folks that don't have walls that are along the project perimeter walls, those lots are also going to be impacted because they're going to receive a benefit of not having to pay for certain improvements on the walls that are a part of the HOA dues that, as we talked about in the public report and in the CC&Rs, clearly lay those responsibilities on the shoulders of the HOA. So if there is a new definition of party wall that redefines these project perimeter wall obligations, that's going to affect everybody, not just those that have the walls right on their property.
Historical precedent as well.
Okay. Okay. So, counsel, is there an issue with maintenance of the Woolley wall?
Yes.
Yes, there's a yes. So, and I'll answer the question a little bit lengthier. I'm going to point you to this minute entry that we have from January 20th of 2011. This was the last neighborhood-wide effort to remediate the failing stucco and monuments in the Greenfield Lakes community. And this minute entry reflects a 3-month project that the HOA undertook exclusively and didn't ask for contributions from any of the lot owners. And if you look at page 2 of the minute entry, you can see that this monuments, I'm sorry.
I'm having some difficulty with it.
The monument upgrades and community wall painting project was undertaken by the board of directors. And as described here, it's going to take 3 months to complete. That's not one lot owner's wall. That's the entire community. And more people are facing the same issues that the Woolleys and the Arthurs are facing. We need to upgrade the monument support. We need to redo the stucco. These walls weren't meant to last for this period of time without maintenance.
Okay. So in your complaint and in your motion, you specifically address damages incurred by the Arthurs. I didn't see that same specificity as to the Woolley. Is there an ongoing maintenance problem with that wall affecting the Wooleys? Is there a cost being incurred now by either party regarding the Wooleys wall?
Not yet, Your Honor. We don't have any hard price tags for work that is being done or that is going to be done during the course of litigation necessarily, but we expect that it's going to happen.
Okay.
They stated that publicly. That
okay.
All homeowners need to prepare to receive invoice.
Okay. Yeah, and so I mean.
Thank you. You're out of time.
I apologize. Thank you, Your Honor.
You have 1 minute left.
I have 1 minute. All right, I'll address everything in 1 minute, Your Honor. A lot of the evidence that counsel discussed is not on the record. He says 99% of cases the wall is on common area. We've shown you several examples where the wall is split between the two and, in fact, entirely on the lot. And that's the only survey on the record, and that's uncontested. Additionally, that 2011 maintenance that they cite, that was power washing and painting the association's side of the wall. It was making the community pretty again. Now, that's regular maintenance that the association would not need reimbursement from the owners for because it had nothing to do with their side of the wall, i.e. their backyards. Counsel cited to another case that was litigated between the HOA and a separate homeowner. That case was settled privately. It had no decision on the merits and it has no relevance to this dispute. And then that proposed amendment never passed. The association's empowered under the CC&Rs to propose amendments to the membership. And if the amendment never passed, there's no dispute over that amendment. And all that amendment did was try to clarify the parties' rights regarding the walls, because obviously there's different interpretations of the CC&Rs. And it wanted to clarify that these were party walls. And I'll rest, Your Honor.
Okay. Even if there is not presently a proposed amendment, what would prevent the homeowners from seeking injunctive relief, anticipating that that amendment was going to be refiled? Or do they have to wait until it's refiled and then run back here and seek an injunction?
That's correct, Your Honor, because we don't know what the language of any future proposed amendment would be. This one was proposed and failed, so it's not even applicable to this case. We're under the original CC&R language. Any future amendment, presumably, even if it were identical language, if 100% of the members approve that amendment, it's a valid amendment, either under the amendment provisions in the CC&Rs or the Callaway case that they cited that requires 100% approval for amendments not tethered to the original CC&Rs. So presumably a future amendment could pass, and that threshold depends on what's in the amendment.
Okay. Well, thank you, gentlemen, for coming in. I'm going to take this issue under advisement. I've got a few minutes. It's going to take me to shut things down. So don't take this again. So thank you both. I'm going to take the matter under advisement. I will issue a written ruling as soon as I've had a chance to consider everything. Okay.
Thank you, Your Honor.